Hello dear friends, Namaste to you all. I am now going to discuss on Unit 5 Factories Act, Unit 5 of Labour Law 1, Factories Act 1948 and Payment of Wages Act 1936. Let me now first discuss with reference to the first part of the Unit 5, that is with reference to Factories Act 1948. Its contents, in its contents it deals with objectives where we need to define the purposes of the act, the definitions. Not all the definitions, some three definitions like a factory, manufacturing process and occupier. These three terms we will define. Then from the point of examination or even from the point of any other, those three are essential. Then we will move on to occupier is defined and its powers and functions are also defined in section 7. But then we will move on to that inspector, powers, functions under section 8 and 9. And his powers and functions, I don't need to explain his powers and functions right now, because his powers and functions are centered around these many, section 11 to section 84. Those many sections, because these are the provisions. And then certifying surgeon under section 10. Who is certifying surgeon? And what for he is appointed by the employer? When he will be disqualified from acting as a certifying surgeon? It may be coming for short notes, this one. Inspectors may be coming to explain the... Usually, in Unit 5, if any question is to be asked from Factories Act, these will not find a place, because there you will find two essay type and two short note type. But Unit 5 will have these two enactments. So obviously you will find two short note, one short note, one problem may be coming from Factories Act, and one essay type question will be coming from the Factories Act, and there will be one essay type question coming from the Payment of Wages Act. So I don't think much importance will be given, maybe coming for short notes, but not for essay type. Essay type, 100% it will be from these many 6 provisions. What are they? One is, they are the basic crux of this Factories Act. They, it's a central point or focal point of the Factories Act. In its objectives, we will discuss that the Factories Act 1948 was enacted so as to ensure, otherwise what would have been? If you refer to the introduction, then you will find the problems like these, that employer was never been concerned or bothered or serious about ensuring the health of the workers, ensuring the safety of the workers, ensuring the welfare of the workers, nothing. No, you are paid wages, that's it. And you do the work and go. The conditions of employment in the factory, your terms of employment is prescribed when you take up the job, that what would be your pay, when you will be entitled to, when you will be provided with the, what will be provided with other benefits and increments and all, those will be there. But when you speak about conditions of employment, that must be conforming to the Article 39 to 41 of the Constitution of India, Directive Principles of State Policy. What is that? It says human conditions of work, just conditions of work, human conditions of living, apart from working hours, special provisions for the special provisions for the protection and promotion of the interest of young persons and women workers, women employees. And there is again, of course, we don't deal with the Child Labour Act, but children can be employed. You will come to know. But who is that child who can be eligible? Whether he or she, gender neutral it is. Children could be employed provided that child should have completed the age of 14. That means if a child is in the first moment of 15th year, eligible to be employed, but whether qualified to be whether fit enough to be employed, that 14-year completed person may have to be sent for medical examination. That we will discuss when we refer to the 7th point that I have written concerning, is it 7th point? Yes, 7th point concerning employment of young persons. 11 to 20 dealing with health, section 21 to 41 dealing with safety, section 42 to 50 dealing with the welfare, section 51 to 66 dealing with the working hours of the adult, section 67 to 77 dealing with the employment of young persons, and section 78 to 84 dealing with the annual leave with the wages. Annual leave with the wages for both in the sense for adult worker as well as child worker, right? Now, when we read that introduction, we will look to not only the objectives but also reasons behind the passing of the Act of 1948. What are the reasons for the passing of the 1948? If we look at, these are the reasons, because these were not ensured. There were hire and fire method adopted by the employer. 1. 2, there were working hours at the dictation of the employers, and if you would have raised your voice or revolted, then it would have resulted in some action against you. So you would always, you at the weaker end, and that too in a country like India where we are suffering from acute problems of poverty and illiteracy, apart from our lack of reliance on the leadership skills, lack of reliance on the institutional stakeholders, lack of reliance on your own ability. These are all, that's what we face in India, especially as I said, poverty and illiteracy. Obviously, they won't be filing any objection. They won't be, resorting to any sort of, objections against the employer. Why? Because they think I was jobless, penniless, but I have been provided by the job. And when I am provided by the job, it's my, onerous duty to conform to whatever employer says in the discharge of the job. And if you have a plan, like I am telling you, daily working hours in the act prescribed. Now I am telling you, prior to 1948, if there was no enactment regulating the working hours, so what would have been the case? I go to the office and come back in the evening. But even before today, I would have made my schedule very clear. Tomorrow evening at 7 o'clock I will come, like that. I mean, we undertake. It's not me. It's every one of us. Make our schedule very clear. And that schedule need not be confined to this week. There are persons like me and you, keep the schedule for months together. I will come on today. Now we are in June. I have already scheduled October 20, 21, 22. Imagine. So we have already scheduled. But it's all possible in the organized sector where we are governed by statute. What about? And where we are governed by statute, even the unorganized sector today, they are given some sort of protection by the government by way of statute. But what about I am talking is that prior to 1948, there was no statute regulating. There was enactment, no doubt. But those enactments were never helping. And the working hours, leave with wages, leave. Then regarding other facility like whatever facility of employment, whatever facility in employment provided, accept it. No voice. You would never raise voice also. I know it. Because when you are paid, that's what you are paid for, the work to be done. And you are doing the work. You are not thinking beyond, hey, where I am working, whether the conditions of employment should be good, where I am working, whether any facility is provided, where I am working, whether the extra leave is provided. You would never think. But those are all thought of. And these many were at suppose if you meet with an accident in the course of doing the work, gone. Your disability means your disability in continuing the work. But that's not the case today. You are entitled to leave, facility, wages, compensation. That is what we call it as a disablement benefit. If dies, death benefit. So many to the dependents. So many benefits are there. But in the older years, prior to 1948, it was not so. Take up the employment, found eligible, continue. But if you object, no. What about service conditions? Nothing. Next year, what is the salary? Some increments will be more. Some salary enhancement will happen. Nothing. It will all never happen. And if at all you would go to the employer seeking the salary hike, what would happen? What would happen is that you will lose a job. You will lose a job. That kind of a hire and fire method adopted by the employer, and that resulted in some sort of the commission, Royal Commission on Labour again worked on it, and the government of India then passed the Factories Act in the year 1948. Okay, not that the Factories Act was not in existence prior to 1948, was in existence, but in what form? There were no provisions, special provisions for the young persons. There were no leave with wages earlier in the earlier enactment. But all these have been answered to, and these provisions, are also in conformity with the subsequently came Constitution of India also, right? And these are the objectives. I said when we deal with the introduction says without these provisions, what would have been the plight of the employees? What would have been the plight of the workmen? These would have been the plight. That no security like safety, health, welfare, working, employment of young persons, annual leave, with reference to this, there were no regulating provisions. And that would have resulted in serious problems to the working community, to the employee section. Hence, this enactment got passed in the year 1948 by assuring all these. In fact, these may be there, but when we read any book for that matter, these are the three areas where Factories Act is mainly focused upon to ensure health, safety, welfare of the employees or the workers employed therein. And they are discussed from 11 to 50. Very interesting, but let me now briefly touch upon these aspects, very brief, because anyhow, whatever explanation I offer, my explanation should offer so as to tempt you to proceed. As I said, introduction, I gave what is the introduction, what is the reason behind the passing of the act. I have given, without which what would be the case. Can you think of? Those were the cases earlier. There were no cleanliness, there were no spittoons, there were no latrine urinals, there were no, the working environment was very, very unhealthy. There was no provision at all. You could not have complained to the employer about this also. What is that welfare facility? No complaint at all. Ultimately, I have taken up the job, I earn a salary, I don't know how long I will work. I don't know about my family. I take up the I earn the salary and take them along to my family, but there is no guarantee that I will, survive my work tenure. Reason, the conditions of employment that are provided in the workplace are such that they are all at the dictation of employer. Employer would not be bothered to spend even a bit for other, because he pays the salary, he pays the wages, that's it. Over and above that you cannot complain. Who says? Employer. But now Factories Act we have. That's why the objective is this. Problems of yesterday have been remedied. And with the remedy that is provided, Factories Act, we find that those problems are obviated, resolved by offering these remedies. Those remedies are nothing but objectives. That is, to provide health, to secure, to promote the health, welfare and safety of the workmen, apart from guaranteeing the working hours. Of course, working hours you will find many provisions. Then employment of young persons and annual leave with the wages. In case if these provisions are violated by the employer is liable to penalty. And he is also, suppose if he is guilty of the repetition of the violations, he will not only be exposed to penalty, but also he will be exposed to, I said repetition, he will be exposed to punishment. This is where this provision, punishment aspect will come after 84. I think it is mentioned in 86, 87 penalties in the Factories Act. Right now I have mentioned the objectives. Therefore, this is a social security provision, social security measure to promote, to ensure, to secure the health, safety, welfare. That is the main. Other things are there. They are objectives. But basically this, without this, what's the fun of having these, many assurances? No, these are a must. These are a must in a workplace. And these are not headache. I said, if you provide, that is the reason why Factories Act passed. If you provide all these provisions, health, welfare, safety, some people would say that it is a waste investment. But I would say that, I mean out of experience, not mine. It is stated by the Supreme Court. Welfare provisions, health provisions and safety provisions for which employer necessarily needs to spend money, they are not waste expenditures or dead expenditures. They are best investments which would yield better dividend or better results, better returns. Supreme Court said. And that is true also, because when this is provided, when these provisions are guaranteed, more or less the relationship between employer and employer will always be clear, crystal clear. There will be no rift like situation like lockout, employer resorting to lockout, employee resorting to strike. So many things, even layoff or retrenchment measures also will not arise, because you will keep continuing, and that will only promote the employment. When the employment is flourishing, there is no question of terminating or laying off the service of any workman. And when the workmen are happy, because apart from the wages, the employer is investing too good of investment, too good of expenditures with respect to promote health. And when we know the measures, you will come to know what is that. Therefore, by carrying out your industrial or whatever activity, you don't be under the impression that employer need to spend so much. No, you don't. When you earn, by selling a product, you earn 100 rupees. From out of the 100 rupees, actually for the payment of salary, you are only spending about 15 rupees. Remember, you are only spending 50 rupees, I said. Remaining 85 rupees what? Okay, some 15 rupees, 15 to 20 keep. 15 to 20 rupees is towards salary. It's about 10% towards payment of taxes. About actually law says 11% is the maximum you can keep. The managerial remuneration, profits and all, but you keep, okay, right, 50. Then you need raw materials. Work will not come that easily. You need raw materials for producing whatever. You need advertisements, marketing, whatever needed. You need various infrastructural expenditure, that is continuing expenditure you needed. Don't think, because in non-application of minds, people who do not have mind, people who have mind but do not apply it, they think that, hey, we make employer to earn 100 rupees but he pays only 10 rupees, 15 rupees. That mean-minded we should not be. Because employer, out of the 100 rupees, though he pays 20 rupees by way of salary, remaining 80 rupees are reserved for so many reasons. Imagine out of that even some portion to ensure your great future. Remember, what is that? Provident fund, gratuity, bonus. These are all paid from out of your salary. No, these are all guaranteed to you as part of a gift in sincere and honest service that you are rendering here. And I am taking care of you. I will ensure that it is. You go to some establishments, not to all establishments. You go to some establishments at least, some 50 to 60% of establishment where the environment prevails in the industry, whether it is precincts, whether it is premises of work. Precinct means it is within the compound. All places are not working place. All places are not working place. There are some places which are precincts attached to that. When there is an apartment, when I enter the apartment inside, yes, the inside is called house. But in order to approach the apartment, I may use the passage, I may use the staircase, I may use even the lift. They are called precincts. So without using the passage or the corridor or the lift, can I reach to your house, to your apartment? It is not possible. That is why I said, inside, when I open the door, inside I find is your house. But to approach your house, I need that precincts to be used. Even precincts are also called house there. Therefore, even precincts are also called factory. I will define that. Okay. Therefore, objects are these. To ensure this health, safety, welfare, employer needs to spend quite a lot. Therefore, I am telling you that employer, in order to ensure all these, he incurs huge expenditures. So the employees or the workmen, they must be mindful of that also, about the proceeds, how much they earn. Employer has got so much of obligations towards that, starting from salary, ending with the profits, etc. Okay, right. Therefore, main objective is this. And the definitions: factory, manufacturing process, and occupier. What is a factory? Factory means, section 2 clause N defines, factory means any premises including the precincts thereof. You understand? Okay, if we read this, then you will find, if you have already seen some factory, you will find, what is that you have seen? There is factory premises, there are restrooms, there are even lawn. Outside the factory premises, within the compound, you will find a beautiful park, a small park or lawn. They are precincts. Because sometimes during the free hours, during the off hours, you can go and relax. But you should ensure that they are secured enough, because under the tree, if you are relaxing, there are possibilities that tomorrow one of the branch of the tree may be falling upon you, and for that, if anything happens to the employee, you are liable, Mr. Employer. Anyhow, I said, even to work, I am not working. Moreover, as per the provisions of the Factories Act, you cannot be asked to work continuously at a stretch for 9 hours. What is the working hour? Daily working hour. If I would ask you, you will say that it is 8 hours. It is not. It is not a factory provision. Factory Act provision says working hours is 9 hours per day. Weekly hour, correct. If I would ask you a question on weekly hours, you will say that it is 48 hours. Correct. But daily working hours is 9. Normal working hours, I said. Daily normal working hours is 9. Weekly normal working hours is 48. And again, you don't exist here as employee or the workman for you only. Sometimes the employer may receive heavy orders. Sometimes employer may want your presence in the factory premises for work beyond the working hours. You can't say no, I have already preoccupied my engagements, therefore I have to attend. I cannot be. It is 9 to 5, I will go beyond 5. Then that will distract you. I mean, that may even consider so many minus points. One day, tomorrow you may be terminated from the job. No, it is not so. You have to cooperate with the employer. Remember, employer will not ask you to do extra work free of cost. Employer will pay rather double the rate for the overwork that you have rendered. And for how many hours you can be asked to remain in the factory. As I said, when you go to the factory, it is not 9, as I said earlier, per day 9 hours. 9 hours okay, but at a stretch if he performs the work or discharges the work for a week or for 14 days, he will be gone. So there will be rest hours that is required. At least maximum, when a workman or employee is working, maximum hours, continuous hours for which he could work is 5 hours at a stretch. Continuously, a person cannot be asked to work beyond 5 hours. If you are giving the break after 3 hours, suppose 2 breaks, fine. But problem comes. Law says at least once in 5 hours you must give the break. So if 9 hours per day is a working hour, then I will get 1 break. Correct? I will get 1 break. A break of half an hour minimum. But normally what happens? If so many breaks, if the employer offers so many breaks, then it will lengthen, inflate the total spread over of working hours. I said, what is that? Spread over of working hours. Okay, I will tell you what is that. Daily working hours, usually 9 hours. And if you are asked to do extra overtime hours, maybe 1.5 to 2 hours, right? Then it's already now 11 hours. Don't you need rest? It has to be needed, and you have to show it in the register that they are provided with the rest hours, their lunch hours, etc. You have to show to the inspector. Otherwise, it is inhuman working conditions. Therefore, you will have to show remaining 1 hour. You can show. It has to be. Okay, 12 hours it comes. Yes, an employee or the workman can be retained in the workplace, including for work. He can be retained in the workplace for 12 hours a day. Normal working hour 9. He could be asked to work overtime hours for 2 hours, and the rest hours anyhow needed 1 hour. So that will reduce. In fact, you will find 24 hours a day, and there can only be possibility of 2 shifts, not beyond that. But we find there are some factories engaging their manufacturing activity in 3 shifts. It's all possible. I said working hours could be 9 hours per day, but anyhow, in any way, working hours per week cannot exceed 48 hours. But if the employer is satisfied, employer has a fixed working hour is 6 hours or 7 hours per day, nobody can prevent the employer. When you are respecting the law, you are violating the law when you are respecting the law when you keep the working hours a day 9 hours or less than that. But when you keep the working hours beyond 9 hours, normal working hours a day, it is called violation. Lesser than that or this is confirmation or conforming. More than that is violation. But at the same time, when you are asked to do the extra hours of work in times of necessity or emergency, you can't say no. You have to keep aside all your preoccupied engagements and you work. And remember, when you work extra during the day, it will not be profit to the employer. It will be profit to the employment. It will be profit to you. Why 9 hours a day will fetch you about 500 rupees. That's what normal wages for you. But this 1.5 hour or 2 hours extra work you have rendered, you will get as good as normal 4 hours working working hours wages, almost half. Because you are already exhausted 9 hours. You cannot be asked to work overtime for beyond 2 hours. But when you are doing the 2 hours, it is as good as you have done 4 hours. That means they are paying you double the rate of normal wages. Wage will be paid. So it will be in a way a loss. But no, you don't worry about that. But that is what the requirement for the employer, working hours, that like that it is designed. What is factory therefore? During the working hours, as I said just now, it is 1 hour you have seen. What is that 1 hour? Either it may be lunch hour, either it may be some some break, rest hours, etc. During the rest hours, what a lady will go and women workmen or male workmen, they will go for once 2 or 3 minutes, they will go freshen up themselves, then they will come out. Some will sit in the restroom, some will sit in the lawn and taking rest so as to engage themselves to be very healthy. They may go out and sit in the lawn so that a fresh environment they can find for their quality health. Okay, you need for that also places. Oh, those places are considered to be not, actually speaking, those places are not working place, but those places have become working place. Reason, factory says, factory definition, factory means any premises. When I say any premises, it means premises where work is going. Any premises including the precincts, that's what I said. Precincts, corridors, lawns, restrooms, they're all precincts attached to it. And in one case, precincts are even included beyond that. In Gopal Rao versus Andhra Pradesh, what happens, there, cigarette manufacturing factory situated in Bombay, and in Erode, okay, it is a Erode case, sorry. What happened? They grow tobacco leaves, and the agriculturist farmers, they grow tobacco leaves, and they will bifurcate the tobacco leaves, and then they will some process they will carry out initial. I think it is called, it is dry tobacco leaves getting dried, and you will have to sprinkle it a little bit of water so as to humidify it, so it got softens, and then you can remove the hard portion. It is called stalk, bennelub stalk. You have to remove. Why? Those tobacco leaves then will be bundled into, and then it will be packed. Okay, understand? And before this, you have already bifurcated good one, medium one, etc. And then removed the stalk, and you have sprinkled water, softened it, then little bit dried it, then packed in bundles, sent to Bombay. A process which you have undertaken in Erode by purchasing the things from tobacco leaves from the farmers. The Bombay ITC factory had an office here, where in Erode. These office people will purchase from the tobacco leaves, and they will follow all these process here. They are not manufacturing BD or cigarette. They are just bifurcating and packing those in the form of a bundle and used to send it. There they subject this tobacco leaves for drying and powdering. Then ultimately cigarette will be manufactured. All these drying, powdering, etc. These mechanized process will be undertaken there in Bombay, in the ITC factory. I'm not talking about Bombay. I'm talking about whether the premises here, where in Erode, where they purchase the tobacco leaves and subject them to some sort of a process, does it amount to factory? It was said yes. The court held it's a factory. You don't manufacture, but it's a process that is essentially needed for the ultimate, what is that? Ultimate produce. What is that ultimate produce? Ultimate, a car I will give for service. Ultimate produce is cigarette, I said. A car, I purchase and then I will give it for service. In service, you undertake so many processes, but don't you think each and every process is interlinked? It is needed. And therefore, all those processes, unless it is carried out, the service will not be completed. It is also, why I am telling you, it is manufacturing process. What do you mean manufacturing process? In factory, you will find several, course of manufacturing process, not one. I said when I give the car for service, how many activities they carry on? Oiling, what is that? De-oiling, they will remove. That is also a process. Then washing. Then what is that called? Finishing. Then cleaning. Then lubricating. No, I don't remember all those activities. That's what it is said, manufacturing process. Ultimately, what is that? Manufacturing activity means, before that I'll just complete the factory definition. Factory means, I think you have got it. Factory means any premises including the precincts thereof, whereupon any activity is carried on or any manufacturing process is carried on with the help of 10 or more persons where power is used. with the help of 20 or more persons where power need not be used. This is factory. What is the factory? It means any premise or including the precincts thereof, whereon any manufacturing activity is carried on in any premises with the help of 10 persons where power is used. With the aid of the power, it is enough if the manufacturing activity in the premise is carried on with the aid of the power 10 persons, not 10 or more, 10 persons also enough. But where 20 or more persons are there, hey, that particular premise, it cannot be called. If there are persons, say for example 17, imagine 17 persons are employed by the employer in the factory where power is not used. For carrying out their manufacturing activity, power is not used. But how many employees have been employed by the employer? 17. It is not a factory. Why? Without using the power, suppose a power, you do use the power, nobody will insist. But if you are carrying on any activity without the use of power, then you can be still a factory, provided number of the employees in the carrying of that manufacturing process. If number of the employees in the carrying of that manufacturing process which is carried out without the aid of the power happens to be 20 and more. If it is less than 20, no power is used, you are not a factory. If it is 20 or more, no power is used, you are a factory. Yes, power is used, you are a factory. Power is used 10 or more. When power is not used, 20 or more should have been employed by the employer in the carrying out that manufacturing activity. What is that manufacturing activity? I don't manufacture any power. This is the definition of factory, I said, section 2n. But manufacturing activity, what is that? It contains 5 different groups. Let me tell you, I am not going to quote, I can't even remember all those. But first, manufacturing activity means any activity for the purpose of. They start with manufacturing activity means any activity for the purpose of. What is that? Cleaning, lubricating, braking, fitting, refitting, cleaning, oiling, then painting, then washing, then servicing, then assembling. So many. If you are a mechanical or electrical or electronic expert, you can use. But why do you do all these kind? As I said, when I give the car for service, from beginning till the end, you carry out several activities, and then you will call the customer, sir, your car is ready. So as to inform him when the customer came, or you go and pick the car for service. From there onwards, how many activity that you carry on so as to finish your purpose? What is your purpose? That is to service the car. So as to service the car, what all activity that you have carried on? What all activities? It is not one. There are about 7 to 8 normally they carry on. What is the objective of carrying out of any of these activities? The objective in the carrying out of any of these activities is to ensure the service or the good to find a finishing touch for the purpose of satisfying human needs. Correct? For the purpose of satisfying human needs. When this chalk piece is ready, this chalk piece, in order to keep this duster, for example, duster manufacturing in a factory, if this is to be sold in this form, it has got several purposes. But I think they would have carried out about a carpentry and pasting and manufacturing of these. So many activities. Why do you carry out those activities? So as to deliver, so as to use this product as a consumption product, so as to finish. So in order to see that it will be given a final touch for the purpose of consumption or delivery or for use, we are carrying out the process. I will tell you, petrol bunk, where it depends how many number of employees are employed therein. In the case of petrol bunk, where the number of the persons employed therein, if it is 10, because power is anyhow used, what petrol bunks normally they do? There is an underground tank, and they will store petrol, gas, diesel, etc. They will lift. It is also one process of a manufacture. Then transmitting, then storing, transmitting, and transmission of power. Yes, we have in Bangalore. We can see in the bigger cities. You can see that high tension wire, the power will come and it will be converted into the need, whether it is industrial, whether it is domestic, and then again transmitted. These centers are there. Whether those centers will become factory? Yes. Look, this is a manufacturing activity. But whether it is a factory depends upon whether 10 or more, power is very much there, 20 or more without power, like that. Then typing, lithography, printing, manufacturing process. Then storing, the goods in cold storage. Storing goods in cold storage, especially perishable goods. And there, power is very much used. Now you have to see, when it is a manufacturing process, where the manufacturing process is carried on, a place, whether it is a factory, depends. Anyhow, power is used, anyhow it is cold storage, but in order to be, anyhow it is manufacturing process. Whereupon any manufacturing process is called, if the premise is to be called factory, when the power is used, at least 10 should be there. If it is less than 10, you cannot be a factory as such. Then occupier. So you will find these many activities. There is also one more. What is it? The supply of water, BWSSP. Their job is also a process of what is that called, manufacturing process. Then we have what? Occupier. Who is occupier? Occupier is the person who has the ultimate control over all the affairs of the company. Okay, if it is a company, then occupier will be the director. If it is a partnership, occupier means the particular partner who is entrusted. If it is a government undertaking, then the authority to whom this is entrusted by the central or state government as such. So you will find that kind of duties that are entrusted upon the occupier. Who is occupier? One who occupies. Normally, a manager is occupier. If the manager is not appointed, then employer himself is the occupier. It is better. What is the job of the occupier? His job is to ensure that the relevant provisions in the factory are complied with. Ultimately, he will be responsible. When the inspector comes, if he finds there is any lacuna, if he finds there is any shortfall, then for which he will hold the employee or the occupier liable as such. Right? Then we can go to that inspectors. What in the inspectors? Inspectors are appointed by the government. Okay, state government, appropriate government. What is the job of inspectors? The inspector's job is to inspect. He should, for conducting the inspection, he should make entry into the premises, and he is a person appointed as the inspector. There are chief inspectors, there are inspectors in the supporting staff. Okay, when you have got support staff, the chief inspector or deputy chief inspector, whoever it may be, their job is to entrust the deputy chief minister and other deputy chief inspectors and others. They will perform the function as assigned to them by the chief inspector. The chief inspector or other staff, in order to supervise, in order to oversee the factory provisions, you need to bother about what are the essential objectives of factory act. The factory act provisions are to be complied with you beyond doubt, complied by you, and they are health, safety, this, that, etc. Now needed. Health provision contains so many things like cleaning, like painting, like washing, and whatever, or working hours, etc., etc. Have you kept the registers? Now I can also, talk to the employees or the workmen there. I can also talk to the employer workmen so as to ensure whether employer or occupier is providing or complying with all these provisions. That's the one thing that occupier is complying with or not. He can examine by verifying the records, by actually talking to the persons employed, and if he finds that everything is okay, fine. If he does not find, if he develops some suspicion, then he may seize those documents. He may summon for production of documents, like register of adult workers, like other registers, which shows at what particular frequency interval the other provisions have been carried on by the employer. All these. Inspecting staff, their job is that they should not play. They should ensure that they will do the job of inspection sincerely. Then only I think these provisions are administrable according to the true tenor of Factories Act, according to the true spirit of the Factories Act as such. Okay, that is there, section 9, 8 and 9, dealing with the. And he can also prosecute the employer if the employer does not conform to the provisions of the Factories Act. Then certifying surgeon, whose job it is to employer in the day-to-day work as a routine process. He may send one person For example, a season like now, if an employee develops some sort of illness, employer immediately send that employee to whom? To certifying surgeon. Here. Why for? For medical examination. And it is so essential in the case of child workers. Who is a child worker? One who completed the age of 14. Whether child worker can be employed? Can be employed. Completed the 14, not undergoing. Completed 14. I mean to say that he is in the first moment of 15th year. He can be employed. No worry. But he cannot be employed without conditions to be fulfilled. What is that condition? Say for example, I am the employer. He or she is a child. Okay. Now, this child has completed the age of 14. That is in the 15th year. And seeking an employment. I said, okay, I can employ. For various reasons, right? Then you cannot be employed though you have completed 14. Though you are in the 15th year, you cannot be employed without complying with the provisions. You will be sent by the employer to the certifying surgeon. What for? Certifying surgeon should be informed or intimated. See, I am sending a child worker, completed the age of 14, okay, but not completed the age of 18. I am sending him. I am going to take him for that particular job. I will specify whether he has got mental and physical fitness. You have to certify. And if you certify and finds he is fit, fine. You will give the fitness certificate. That has a token. Okay, that has to be displayed by the child worker in the course of at the time of the work, right? But this is valid. This certificate is valid for 6 months, and it can be even earlier. Even earlier, it can be re-looked. And say for example, after granting, normally its validity is 6 months. Not that it will remain for 6 months. If concerned person develops some doubt regarding his competency, regarding his fitness, then he can be sent. Maybe after 2 months they developed why he was having the fitness, but right now, then again he will be sent. And in the course of that examination, if the certifying surgeon finds that he lost, then they will revoke the certificate of fitness. Like that, a provision is there under 7th point. So certifying surgeon's job is that to examine, to conduct a medical examination, to conduct examination to ascertain whether he is a child worker or whether he is an adolescent worker, whether he can be fit enough to take up the job specified to him by the employer. Like that. This is your job. But you will be disqualified to be a certifying surgeon if you become employed in the industry. And if you are employed in the industry, Mr. Certifying Surgeon, you become the employee, then you will give certificate as per the dictation, because you are also one of the employee. What kind of certificate you will give? You will give a kind of certificate so as to satisfy, so as to please your employer that time. If the if the certifying surgeon becomes employed, he is disqualified from acting as a certifying surgeon. If the certifying surgeon acquires interest in the establishment, he will he'll be disqualified from acting as a certifying surgeon. That you will find in section 10. Okay, so that is finished, initial provisions. And now let us fast proceed to these provisions. What is the health provision? See, section, as I said, 11 to 21 dealing with the health provisions. What are all those health provisions? See, I am telling you, you kindly follow them. Health provision number 1, cleanliness. Cleanliness provision consists in, imagine that this is the workroom. Okay, imagine that where I am standing right now is a workroom. And there cleanliness is very much required. I am writing on the board. It means I am doing some work, but in the course of doing work, dust is accumulated here and there. And there must be provision for the removal of dust. That's what I am telling you. Premises should be clean. It should be healthy. And the starting point of the health provision is cleanliness. When I say cleanliness, it's it's in a sanitary condition, hygienic condition, in all sorts of that. There should not be any waste. There should not be any dust. So many things. When I speak of this workroom, then it speaks about the floor. It speaks about the ceiling. It speaks about the wall. It speaks about the ventilators, the ventilation, that is like windows. All those, they must be kept clean. How? If it is ordinary painting, it should be painted. If it is line painting, it should be painted at least once in 6 months. If it is distemper, like once in a year. I said Then if it is a waterproof paint, once in 2 years. This is the rule. You spent for a liter of a painting, you spent so much, 700, 800, such quality, you spend whatever amount, it is still called waterproof paint. 2 years once you have to conduct the activity, carry out the activity of painting is what section 11 says. But if you want to be exempted, how can you exempt? How can you want that exemption? Saying that, see, wall portion is still so good, why should we paint? Then get it inspected by the inspector. You understand? Get it inspected by the inspector. He will see that, exemption could be granted. State government is empowered to grant you exemption from this, carrying out of a painting process and all, if you are able to maintain it in a healthy, hygienic condition. Then you don't need to. But otherwise, you need to bother. That side walls, privies, floors, etc., all these must be kept clean as such. Regarding conducting of painting work, one more thing, you have to maintain register also regarding this. You have to maintain register. Did you carry out these painting work, etc.? Then on which date? Contained in the register. Okay, right. Cleanliness. Section 12 says disposal of waste and effluents in the course of manufacturing activity. For example, a kitchen in the hotel, so many waste and effluents will be there. Okay, these shall be disposed of. Where? Not to throw it on the roadside or elsewhere. It will be very causing danger to the human or an animal living as such. Properly dispose it of. Provisions are to be made for disposal of waste and effluents. And the third one is, you speak, it deals with the removal of dust and fumes. Removal of dust and fumes. Dust and fumes may be stored, accumulated in some corner or privy of the work premises. There must be provision of exhausters. Then there must be provision for ventilation, not ventilator. He said if you don't provide all this, then probably he may have to be given ventilator facility. It is quite dangerous. It becomes hospitalization. Ventilation, proper ventilation, windows of proper quality, and there should be supply of fresh air. There should be provision. Ventilation not only on the one side, ventilation on both the sides, so that the incoming and outgoing air, that will frequently happen. Then there is a provision for what is it called, artificial humidification. If the working environment is so dry as weather like Bangalore, where the dry weather prevails, in which case you will have to humidify the dry weather. Dry weather is not good in any sense for the skin or for your face, not good. Your health will be affected by that. You may be exposed to some diseases. Therefore, in the work premises, workplaces, employer, in which case where the dry weather condition prevails, you will have to artificially, like water cooler and all, you can be deploying for the purpose of increasing the humidity level, water content level in the atmosphere. Okay, then you will find no overcrowding in a workplace. No overcrowding. Why? In the bus how it is. If the overcrowding happens, suffocations, lack of oxygen, then accidents, whatever, those will be the problems. And accidents may be causing some serious consequences. Then there should not a lighting facility. In the name of providing lighting facility, normal lighting facility, that light always rely on natural lights. But when even natural light is not helping, then you can go for artificial lighting. A lighting facility is provided to lighten the environment. It should not be adding to the temperature in the workroom. As a result of so many people there in the workroom, appropriate number, plus in the workroom as a result of mechanization process, that means engines are on, they are working, the temperature of the room will not be the same normal temperature elsewhere in a room. What would be the temperature? It cannot be, because frequent movement, frequent operation of the engines, etc., temperature will go upwards. And over and above, this lighting system that you are providing should not be adding to increase or inflate the temperature level. Therefore, provide such lighting where it will not increase the, increase artificially the temperature. 1. 2. Provide the lighting facility at such a height, because it should not be too close to have any access with consciously or inadvertently. You may be moving here and there. That time, if you are hit inadvertently, then there is a possibility of electrical shock. Therefore, beware, very careful, right? The lighting facility should be not a gray, what we can say, a glazing lights. When it is there, if I see that, it's very glaring. And when I see, upwards the glaring light, and when I see here, it will be very dark. Likely, accident is very much, likely. Therefore, lighting facility, lighting materials that you provide must be normal one. But adequate lighting should be there. It should not be more. It should not be over. It should not be even, lesser. Then you will find latrines and urinals. Latrines and urinals must be in good numbers. See, you cannot keep. There are how many employees there in your factory? 100. 100 to 1. Is it enough? Oh, it is more than enough. How is it enough? It is not enough. The other person will have to be in the queue, or the other person, because of that, his health may be affected. So in good numbers, if you are having 100 members, at least 2 or more places, 2 to 3 places, you better have it, or at least minimum in the sense 25 to 30 members, separate accommodation. So I mean to say that there should be 2 anyhow will be there, no worry at all, because if a separate accommodation for male and female. In addition to the 2, provide 1 extra each to each of them, so that it will be conveniently used. Otherwise, it may cause some health hazard. Latrines and urinals. When I say latrine and urinals, come back to section 11. It should be clean. It must be usable like. So I said the sanitary condition. I said the floors, the walls, etc. I mean the wall portion of the toilets or the bathrooms, they must be fitted with the adequate equipment. I mean adequate materials like cladding, not granite. I said the same stone is available. You should clad it so that there will not be any problem regarding maintenance of its cleanliness as such, right? Then you have got what is that? Drinking water. If you are employing, if your industry has employed 150 workers or more, then separate drinking water facility should be there? No, it is not. Whether it is male or female, drinking water facility should be at such place, not near the toilets, not even at the entrance of the workroom, but it must be accessible to the employees who are working in the workroom. So it is there. But the place where you have employed this drinking water facility must be clean, hygienic. Then if number of the employees are employed in the factory are 150 and above, then separate accommodation shall be given to male and if 150 or more members are employed, then you should provide separate water, drinking water facility. That is, during the hot season, like summer season, you should provide both hot water as well as cold water. During the cold season, you should provide, anyhow the normal water will be there. I don't say during the cold season, winter season, you provide cold water. I say that normal water and hot water. So these 2 separate water supply should be there, and it becomes compulsory where the number of the workmen employed in the factory is 150 or more. When it is within 150, you still provide. That will be good in the health of the workers. And the last one is dealing with the spittoons. Where it can be spittoons, where it can be deployed. The spittoon should be deployed not at the entrance. Spittoons cannot be deployed near the workroom. Spittoon should be deployed at such and such convenient places. Remember, when you provide spittoons must be kept in gain. Section 11, it must be kept clean. Not only spittoon, the environment in and around the spittoon should also be clean. Therefore, it should be cleaned up at least 2 to 3 times a day, spittoon. If it is not cleaned up, then so many bacteria. I think instead of spitting there, if I go to spit, instead of spitting, I may be vomiting. Those are all the possibilities. I may get infected with the disease. So spittoon provide where to deploy that, where to install that, and how to maintain that. Those to be taken care of. They are the health provisions. And if we go to the safety provisions, no much explanation I will offer. Safety provisions. Safety provisions is that staircase, railing provide. Staircase, the flooring that you provide, it should not be skiddish. Obviously, the worker will be focused in doing the work, and he may have to use these staircases or these lifts, what is that, escalators, whatever you provide. It should not be causing, it should not be, in a dangerous, like what is that called? Granite material you will provide in the staircase. So much so that even you can comb your hair. It is that clean. But if any person's using that, if they are not taking adequate care, what happens? He will be skidded. And if you fall then without, then I think there will be breakage of, mutilation of your parts, limbs. These may be happening. Okay. Therefore, you provide the granite, I don't mind. You should ensure it may be hardened. At some portion in the staircase, provide granite. But at some portion in the line, you may have to be hardening it so as to have the grip, right? Then, second one, adequate railing system. There was a case, if we refer to regarding the safety provision, in the course of the work, inadvertently, there was no railing in the first floor and he fell down. As a result, he died. Who is responsible? Employer is responsible. Why? He did not provide adequate safety provision. Railings should have been erected. Therefore, railing should be there. Hoist, lifts, fire extinguishers, if at all you provide, then a hoist lift must be of proper material. I am using this for lifting. This is being lifted. When it is halfway, it fell down like this. Accident. And under that, there may be persons working. We have example for that also. It happened in the year 2001 in our own rail wheel factory, where the crane was lifting the wheels, okay, for its manufacturing, to fix that axle, okay. But that iron particle, as a result of breaking away of the rope, iron particle fell. The two persons working there underneath, it fell on them and they were crushed to death. It may so happen. Therefore, the occupier or the employer must take adequate care to ensure the safety. I can tell you that it is zero tolerance. As far as the lift, as far as the hoists are concerned, zero tolerance. There should not be any scope for any negligence on the part of the employer, and he should daily inspect and check about its quality and viability, right? Therefore, safety. Then machineries. For carrying out manufacturing activities, the equipment or the machineries have been installed. It should be fenced. If fencing of machinery is not done, what happens? As I just said, even children could be employed. He is not a small child. He is of course a child. He is in the 15th year. He is employed. He may get attracted by seeing those pulleys being operated, by seeing those wheels being rotated. He will go and touch, and as a result, it may rather swing him to its occupation. He may be crushed to death. That is a possibility. So therefore, it must be fenced. Fenced, not only fencing for the heck of fencing, fencing to prevent any access. Then who can get in? Only the person. That too it is said, though you may be adult female worker, though you may be trained, still there is a precaution. Women should not be employed on or near the machinery in motion. Adult women should not be employed on or near the machinery in motion for various reasons, wearing sari, wearing dupatta, etc., etc. Some of them, due to the air circulation, due to the pressure of air, they may be, as it happens in the case of pillion bike riding, it happens for women, right? What I mean to say that experts, trained persons shall be allowed to enter the fenced machinery for carrying out anything, oiling, lubrication, starting, operation, whatever, they must be employed. Then fire extinguishers must be deployed. Then what about pits and sumps? Frequently you keep hearing, persons employed to get into the pit for its cleaning, but unfortunately after entering died because of poisonous gas present over there. Ensure, absolute precautions. Not only one died, when the one is suffocated there, another entered so as to protect him, he also died. 2 days back, it happened. And it happened even in Bangalore, Santosh, near one theatre during Rajkumar, abduction time. It is happening. You will see Chinnubai versus State of Bombay in your book only. You will find the same thing. Accident happened. Employer will be held liable. Employer cannot say that I have not employed them, they have entered. How can? You should, that openings of the pit and sums must be sufficiently secured, maybe locked also. And that lock must be in charge of the person. So you should ensure, because the danger is too high. When the plane falls, there is no question of any survival. Therefore, you should ensure that plane will not fall. Like that. Okay. If it sums, then what is that called? Power. I don't remember the appropriate word. When there is short circuit, then there should be provision for power connection, power disconnection provision should be there.
Trippers.
Trippers that you can use. They must be used in so as to ensure the security, because accident happens. In order to prevent further danger, you must use that device which will disconnect the power supply. That device must be used as a security. And in order to ensure all these, you will find even more. In order to ensure all these, you should also appoint where the number of the persons employed therein happens to be 1,000 members, 1,000 employees or workmen or more, 1,000 or more, employ a security officer, expertise in the field. He must be expert enough in knowing, carrying out, or being expert in training too, regarding these safety precautions. Whose job it is? Safety officer to be appointed when 1,000 or more. It is compulsion. What is his job? To ensure that all these safety measures that are provided from section 21 to 41, they are taken care of. They are adequately provided. They are also updated. There is a fire extinguisher, but it was provided at the time when it was provided. It was new, but it's not been used for the past 8 years. And when some accident like a fire or something happens, when you press that trigger, it is not getting operated. Why? It is like in the bus you will find a first aid box. There will be nothing, or there will be something that is outdated. You cannot. You must update it. So when a safety officer job is to ensure that whatever safety provisions are there, they are adequately administered. Therefore, safety officer's appointment is a must when 1,000 or more employees are working. If it is less, employer, you relieve yourself from the headache. Appoint still if it is less. Of course, law will not compel you to appoint, but it is better to have a safety officer to ensure that absolute safety of the employees. Then welfare. What in welfare you will find? Section 42 to 50 you will find welfare. One is that washing facility. Another one is that storing facility. Another one is that drying facility. See, when I get into now I am in this dress. When I enter the workplace, I may have to change this and wear the factory uniform. Where to keep this? There should be place for storing. There should be place in the evening after finishing this. I may have to be, even in the morning or even during the lunch hours, I may have to wash my hands. That's the reason why this washing place must be kept clean. Going back to section 11, this washing place where tap is fitted with the supply of water at least during the working hours and good water, and this washing place must be available at all times of the work, and there should be storing facility. Suppose in the evening, I may not be doing it on Monday, but I surely do it on Tuesday. At least 2 days once I will wash my factory dress, and wherein there must be provision even for storing, drying. Okay, I don't need to wash only factory clothes. I may wash any other cloth as well. But there should be storing provision. There should be drying the place, and they must be maintained clean. That's what section 42 says. 43 says there must be provision for rest provision, rest hours, resting place. Okay. So rest place should be there. Provision for rest should be there. A place where to take rest, not in the work premise, but in a separate room. Separate lighting, ventilation, all those will come. Whatever we discussed from section 11 to 20, it will be there. When it is a restroom, obviously there will be toilet. Obviously there will be fan, or there may be AC. Obviously there will be drinking water. All those taken care of. Then you will see section 44. You will see a provision for first aid appliances. What is the first aid appliances? For every 150 employees, how many employees are working in your factory? Oh, 850, right. Then there should be provision for at least 5 to 6 first aid appliances box should be in charge of not only one medical attendant. 5 to each first aid appliances must be in charge of separate medical attendant. I didn't say doctor, I didn't say nurse, I said attendant. Medical attendant, one who is expert with the basics of preliminary medication. Okay, for every 150 first aid boxes should be there, and it should be equipped with the first aid equipments. Then you see next, ambulance. Why for ambulance? In case of serious cases, there should be ambulance room. There should be ambulance vehicle. You know what is ambulance vehicle? Necessarily fitted with the what is that called, beacon lights, necessarily fitted with the ventilator, oxygen, etc. Okay. In case if further treatment is required, in that vehicle, he can be taken to the good hospital. Okay. Or else that will be anyhow there, but here only you have to provide first aid treatment as such. There should be ambulance room. Same ambulance vehicle I told you, same thing should be provided even in the ambulance room. It should be in charge of a doctor, a nurse, and a medical attendant. When this is compulsory, first aid appliance is compulsory when 150 or more employed. For every 150 workers, one first aid appliances with the medical attendant. When there are 500 or more, then ambulance should be provided. If there are 2000, then you mean to say that 4 ambulance? No, only one ambulance room. Where 500 or more employees are working in the factory, then the employer shall provide even for the establishment of an ambulance room with all ambulance facility, and it should be supported with even ambulance vehicle. Correct? Then if you go further, section 46, canteen, where 250 workmen are employed, it becomes compulsory for the employer to provide canteen facility. The furnitures, the food stuffs, that etc. They must be very clean. 11 applies. It should be hygiene. It should be in a sanitary condition, and they must be kept clean. Then in charge of necessary employees, what you will charge there? If I am a worker, I will go to the canteen. I want some dosa. Then they cannot charge 40 rupees. They can charge only what actually is needed to prepare that masala dosa. The cook, the supplier, the accommodation, etc. All these expenditure are to be taken care of by the employer. Only the material that is required for preparation of food material that is required, the raw material that is required for the preparation of masala dosa, for that you can charge at a subsidized rate. Therefore, you should supply. It is said. Okay. Then you will see. All these are applicable to canteen. Where even when the employer has not employed 250, you can provide the canteen facility, but it becomes mandatory when you employ 250 or more. Cleanliness provision will attract. Then you will find after canteen, section 47, you go to, I think it is restroom, lunch room, place for sitting again. And when I say room, any room you talk about, whether it is restroom or lunch room, you should ensure that lighting, then all section 11, painting, cleaned, no question of storing of any dust or effluents or wastes. Then you should ensure that spittoon not needed, but drinking water should be there, and the latrine should be there. And in the room, I said there should be separate accommodation of restroom or lunch room for male and female employees. Number is, restriction is not there. Separate accommodation you provide. Then you will find creche or crush. What? Where 30 or more female employees are working in the factory, irrespective of whether they are married, irrespective of whether they are carrying, irrespective of the fact whether they are mothers, there is a compulsion to provide crush or creche facility. 30 or more female employees. And then it depends upon the number of workers. 30 compulsory. If not 30, optional. Still provide, salute. But 30 there or more there, you are not, then I will prosecute. And there are hundreds of, rather 150 of male employees employed, then the creche should be larger, or there should be more of such a creche facility. And it should be in charge of whom? It should be in charge of a attendant, a female attendant rather. And that female attendant must display the absolute personified patience. There are people like you, people like me, we do not have patience. If you get something which is not imagined for, which is not at all expected, something happens, we suddenly lose our temper. Such female attendant should not be employed, because they are the children of the workmen who are working. Therefore, the female attendant having knowledge, having the patience, having what is that called? Having the passion to take care of the children. Such female attendant should be employed depending upon the number. Okay, number of the children. And moreover, remember that creche facility that you provide to the children of the female employees must be within the establishment nearby, because frequently the female workers who are the mothers, they need to go for nursing and all, right? So, and in case if the number of female persons employed there is 30 or more, but employer still not provided a creche facility, employer need to write to the government for its exemption. Even the government for exemption, to grant the exemption to the employer, they should be ensured. Hey, an application for exemption has been made by the employer from the purview of section 48 of this Factories Act regarding creche. If I grant, it would be inconvenience. But such children, all these 30 female employees are not carrying children. Therefore, no children are there. Why should I? Then it will be a liability. Government considering this, at least okay, whether in the near vicinity, whether there is any private creche or crush. If it is there, a near vicinity means maximum means maybe about 200 to 500 meters away from the establishment. If it is there, then at frequent intervals of 2 hours or 3 hours, the mother can go and feed the child as such, or take care of the child as such. Such a provision should be there under section 48, where 30 or more female employees are working, whether they are married or not, it is irrelevant. Then there should be provision for establishment of a creche, or there should be provided a creche facility to be in charge of expert female attendant, how to take care of the children, how to nourish them, how to train them, etc. And then toys, eatable items, children eatable items like good biscuits, Horlicks and milk powders, they are all must be provided by the employer. You can now easily imagine, out of 100 rupees earning, you are paid just 15 to 20 rupees salary, what other expenditures employer incurring, now you can imagine. Okay, then there is one more, after all providing this, there is one more, that is appointment of welfare officer. Appointment of welfare officer is a compulsion when 500 or more workmen are working in the factory, and it is an option when it is less than that. It is a must. And what is the job of the welfare officer? Job of the welfare officer is to ensure that these welfare provisions are adequately taken care of. It is his responsibility to ensure that from washing facility till the creche facility provided. It is like government. Government invests in providing the facility, but it doesn't maintain. What is the use? Nonsense it becomes. Likewise here, factory, employer should provide the facility, employer should ensure that those provisions, those facilities are in good condition, those facilities are in a usable condition. Therefore, it must be in charge of welfare officer, whose appointment becomes mandatory when 500 or more employees are employed in the industry. Employee means workman, whatever it may be. Okay. Then you come to the working hours of adults, section 51 to 66. I will just state, no explanation will be offered. Working hour for adult. Adult I say whether male or female. it says under section 1, it says working hours, weekly working hour 48 hours, weekly holiday first day of every week. Correct? First day of every week. What is the first day of every week? It is Sunday. Weekly holiday. Unless they are displayed by notice. Any other substituted day as a holiday, weekly holiday. That weekly holiday could be either during any of the preceding 3 days or any of the succeeding 3 days. I hope you have understood. Instead of Sunday, that is the first day of every week being a holiday, employer can change it by proper notice. What is the day? Weekly holiday. It is either preceding any of the preceding 3 days. What is the preceding 3 days? Saturday, Friday, Thursday. Any of the day. Or succeeding Monday, Tuesday, Wednesday. Any of the day could be substituted as a weekly holiday instead of the first. That is possible. Section 52. Then suppose if on a due holiday, if you are made to work, then you must be provided a compensatory holiday within 1 month. But what happens in India? I have seen that instead of a strong compulsion to the law, that is, hey, you are made to work on a due holiday. Actually, law says it must be given to the employees that due holiday. You don't ask them to work. You don't ask them to compensation in terms of money. It is wrong because they don't get the rest. There is one more provision. It says that in case if on a due holiday, if you make them work, then there will be holiday less in that week. If you do repeat in the next week, there will be holiday less even during the second week. They say, law says, under any circumstances, if on a particular Sunday, if you are calling them in view of pressure of work, under any circumstances, ensure that, Mr. Employer, ensure that they will not be working at a stretch for more than 14 days. After 14 days, they must be allowed 1 day, full 24 hours break. Holiday, paid holiday. Understand? So, if Sunday is a holiday, if my employer asks me to work, then I should be ready to work also. Remember. And what he may do? This is most important. He should not go for compensating. Hey, you will be given no holiday instead of this. Instead, I will pay you that 1 day wages. You may accept because you get money. But actually, that is not allowed under the Factories Act. You may accept because you get some money. But what about your health? That is gone. Therefore, Factory Act does not allow. Therefore, it says compensatory holiday within 1 month. But what happens sometimes, some good employers, what they do, they want your work, they want your presence. They made you to work on a holiday. That means there is, too much of demand that is doing good to that establishment. What they do, hey, you don't, though the act says within 1 month, but what I say, you can take any day during this year. Which one is good you think of? I am not violating Factory Act. Factory Act says at least within 1 month you should provide. But what I did, I am not confining your compensatory, your entitled leave, I have made you to work. And that day's leave you can take any day during the next, up to December, during the calendar year, any day you take. You will be very happy. Because when during the Deepavali time, if you find, 2 holidays in between 1 working day, then you can club to that working day, you can avail 3. You people are very happy, and employer, where such facility are provided by the employer, where elasticity prevails, then there will be no strike, there will be no lockout, and then the industrial relation will be of higher quality. Understand? So law says within 1 month, but employer says you can avail any day. Workmen will opt this, and if the law then compels the workmen, against the law only workmen or employees will strike. Then you will find daily hours. I said compensatory leave, I will come to that daily hours, 54. What are the daily hours? As I said earlier in the beginning, it's 9 hours a day. Spread over. What is that? 55. Section 55 dealing with 54 daily hours is 9 hours. Section 55 says spread over. Including the working hours, I said there could be overtime working hours. Regarding overtime working hours, there are limitations. You should be doing. If you are not agreeing to the overtime hours, saying I have got personal work, I have to attend my personal family work, etc., then it will attract some disciplinary action against you. You should be working. But when you work, you will be paid at the double rate. per week, the overtime working hours could be 12. So including the overtime working hours, weekly hours, as stated in 51, weekly hours could be 48 hours. Including the working hours, weekly hours could be 60 hours. Now you don't be governed by the mathematics. What mathematics says? 2 into 2 is 4. Therefore, per quarter, what is that quarter you mean? 3 months. Per quarter, what is the total number of overtime hours? If you calculate, it will come to this kind of calculation. Okay. Per quarter means you will get 13 weeks. Correct? 13 weeks. 1 quarter is equal to 13 weeks. Per week is equal to 12 hours overtime could be done. Okay. 13 into 12 comes to, it is 156 hours. Sorry, this is mathematics. But if we go run by this mathematics, it will spoil our chemistry. Okay. Therefore, it cannot be more than 72 hours per week, per quarters. Overtime hours cannot be more than 72 hours per quarter. Not 156. If you find the mathematics, it will find us to this number. But it is 72. What I am telling you, this is the law. But this law, is it a possibility of strict implementation? If it is implemented, will it solve the poverty? Will it solve the unemployment problem? No. I am only stating the law. You don't quote any practical knowledge. Practically it is different. It cannot be strictly implemented, but even it cannot be strictly prohibited or prosecuted. But prosecution could be made because you find a violation. So weekly, daily hours 9. Spread over is including the overtime. As I said, per week, including the normal working hours, including the overtime working hours, it cannot be exceeding 60 hours. Therefore, per week overtime hours could be 12. That means per day overtime hours could be 2 to 3 hours. Imagine that 6 days a week, 2 hours. So your total spread over, you are anyhow there for normal work 9 hours plus overtime hours 2 hours plus this cannot be done at a stretch. You require some breaks, some rest hours, what we call it as rest intervals called. So total 12 hours, including the normal working hours, OT hours and the rest hours. A person, a workman, employee can be asked to be there in the factory premises for work for 12 hours. Not that all 12 hours of work, as I said. This is called spread over. Spread over means including the OT hours, rest hours and working hours. A person could be there in the factory for 12 hours is what section 55 says. Then 56, overlapping of shifts. Then overlapping means one shift ends, another shift should begin. But there should not be overlapping. Even before one shift ends, if another shift begins, it's wrong. Therefore, your shift schedules must be quoted to the inspector also. Then prohibition of double employment. This is all possible. When one show ends, that's what we used to do when we were in our childhood days. We go to festival, we will be there. In the evening we go to our, town, and next day morning we will be there. We will have watched the 3 shows during the festival. 2 different movies, one after another. That is okay, one day in our 1 year lifetime. What about employment? See, I am not greedy of money, but I am in need of it. How much you pay? You pay meager 10,000 per month, but that is not enough for my family to take care of. What I do? I finished my work during the shift, and next shift to begin. I also request the employer, sir, please employ me in the next shift. Whether employer can employ you in the second shift? No. There is a prohibition of a double employment. He cannot be employed. If he has finished his employment in the shift, he cannot be in any other job in the same establishment also. No question of. There are, that is happening. He is shown in one job in the one shift, shown in the other job in other shift. And in the other shift, employer will not pay full pay. Worker will still be happy. Employee will still be happy. Why? He is getting something extra. But that is, don't you think it is exploitation? Yes, that's happening because of our poverty and illiteracy problems in India. But I said that law says prohibition of double employment. Then, prohibition of employment of women in night shifts. Then, maintain the register of adult workers. Adult workers, male or female. Maintain the register of adult workers. Prohibition of women at night hours. What is at night hours? Normally, women can be asked to work from 6 a.m. to 7 p.m. That's what normal working hours of women. They are adult workers, though agreed. 6 a.m. to 7 p.m. their working hours should be designed. Or with the permission of the previous permission in writing of the government, it can be extended to, instead of a normal 6 a.m. to 7 p.m., it can be 6 a.m. morning from 6 a.m. to 10 p.m. maximum. Even the government cannot sanction beyond 10 p.m. because she has maternal function to perform. I said 6 to 10 continuously she will be working. No. Her working hours should be between 6 a.m. to 10 p.m. Her total working hours can only be 9 hours, normal 2 hours, OT and 1 hour, like that. But in how many establishments in India you find this kind of rest hours? Very, very difficult, because where there is a shift working, then scope for rest hours is minimum. Okay, actually per day is 24 hours only, right? Like that I said. Then you will find the register of adult worker. In the register you will find the name, you will find the name, you will find the nature of the worker, you will find the what is that called, the establishment to which, you will find the shift to which he belongs. All these should be there. This is regarding the working hours of adults. And regarding employment of young persons, as I said, who is young person? Persons completing the age of 14 in the first moment of the 15th year. Then if you want, employer wants to employ him, employ, but send that the child worker to the doctor. Doctor will certify when you are sending him for medical examination, you should also inform the doctor that I am going to employ him to that work. Now doctor will be in a better position to examine to that work whether he is mentally or physically fit, and when it is found fit, he will issue a token. This token should be displayed at work, so as to distinguish that he is a child worker. And then child worker lose the status of child worker when he completes 15 years and he is in the first moment of 16th year. When he is in the first moment of 16th year, he is called till he completes 17th year. These two, 16, 17 and 18th year, 18 year completed 3 years, these 3 years he will be considered as adolescent. And when he completes that 15th year, he is in the first moment of 16th year, the doctor will certify, examine, and upon examination, his maturity level, his physical strength level is good enough like adult worker, then he can be posted like adult worker, and working hours also will be 9 hours like that. But a child worker, daily working hours can never be. It was up to 1976, it was 5 hours, but 1976 amendment reduced it to 4.5 hours a day. No question of night employment there. Their employment must be 6 a.m. to 7 p.m. only for 4.5 hours. A child worker. Who is a child worker? 14 completed, 15 did not complete. Therefore, in that 15th year, 1 year, whole year, he will be a child worker. 15 year completed, that is in the 16th year, 16, 17, 18th year till completed, he will be called adolescent. Normal adolescent could be given adult working hours like that, unless he has not still attained that adolescent status, still continues to be in the child status. Okay, right. Who has to apply for that fitness certificate? Either himself or parents or trade union or the manager of the factory has to apply to the doctor for what is that fitness certificate. Then regarding the hazardous employment, no question. On or near the machinery in motion, no question. For operating the machine, no question of employment of a child worker. Then you will find further provisions regarding the child worker, that is leave with wages. I will put it like fast. Regarding annual leave with wages, it's a bonus leave that is availed to you, that is provided to you. It is not casual leave or sick leave. This is called bonus leave or earned leave, we call it as. In case of an adult worker, if he has in a year, normally, how many number of actual working days will be available? It will be available like 290 to 300, 280 to 300, 290 to 300 better, because 52 Sundays will be going, some 12 compulsive holidays, some other, whatever it may be, 290 to 300, you will find the actual working days in the establishment. Out of that, how many days you have worked? How many days I have worked? Hey, I might have availed in the passing years, I might have availed like earned leave in the credit of mine, I might have availed. Or you, the female employee, you might have availed this maternity leave. So many things. But whatever it may be, those are all the approved leave. Say for example, the 25B of Industrial Disputes Act says for eligibility, it says what is meant by 1 year of continuity of service. 1 year of continuity of service means a person should have completed the work for 240 days of work on the ground, or if he is working below the ground like in a mine, at least 190 days of work. This is the eligibility for every year to be counted. You understand, for bonus leave, earned leave from January till December. And when I go to Mr. January next year, then to earned leave account, that 2020 from from January to December is there, 12 months. How many number of days I have worked? I could work only in 2020. If I am a female employee, I work only for about 190 days. That too I am working on the ground. Okay, so 240 should have been there. Why 240 did not come to you? Sir, I was on maternity leave. Maternity leave, nowadays it is 180 normal days to 26 weeks. Plus it can be extended by the certification of the surgeon to 1 more month extra. So it comes to, therefore I could not. In my case, male, sir, I went with an accident, therefore accidental leave. Remember, for conferring the eligibility, understand, for conferring the eligibility, those number of days, like you in your case 180 days of maternity leave, in my case 2 months of medical leave, if I have taken, those will be added, so as to whether after adding that a number of total working days, will it come 40? Yeah, 240 it comes, then I am eligible. But that's what for eligibility. But for actually granting the benefits, eligibility sake we will count. But for actual granting we will not count. For actual granting, what we will count, only this much. How many days you have worked, lady? Sir, I have worked 180 days in that year. Then you are adult worker? Correct, adult worker. See, otherwise you would not have been eligible. But you have become eligible because that less than 240, it came to 180. It is because of maternity leave. In my case, because of the medical leave. Therefore, we would both be eligible. Now, after eligibility is ascertained, then the bonus leave will be granted on the basis of you are adult worker. I am child worker. What happens, in your case, adult worker, male or female, for every year, in the previous year, now we are in January 2021, you will be given to your account earned leave for the previous year's work. What is that? You are adult, for every 20 actual working days, 1 day bonus leave. For every actual 20. So you have worked 180 days. So it will be about 9 days of this will be added. Or you have worked all the days, 280 days, then 14 days will be added like that. Because you are adult worker, for every 20 actual working days in the preceding year, 1 bonus. You have worked 180 days, therefore 9 days. If I am a child, I worked for how many days after accident leave, etc., etc. Say for example, I worked for 90 days, 190 days. In my case, it is not 1 for every 20 days, it is 1 for every 15 days because I am a child worker. So it comes, you calculate better, it comes to about 13 days of earned leave will be credited to the child worker. I hope you have got how to determine then how much you can store unavailed earned leave or bonus leave. How much you can store? You cannot store beyond 30 in the case of adult worker, you cannot store beyond 40 in the case of a child worker. Sometimes what happens, I am already having 40, you are already having 30. Then what happens? When it is November, this year I will get 14 days. It will be unnecessarily wasted. What you will do? In November or December you will apply for leave. Employer cannot deny because it is your entitlement. At that time, if your work, if the employer is doing well in the employment, if your work is absolutely needed, what he will do? He will announce. If he doesn't announce, you all will go on leave, one after another. It will affect work continuity. It will disrupt. Therefore, employer will announce, because he is in need of your work, he will announce encashment of earned leave. That time what you will do? You will never take, even you will hold your marriage during night muhurtams. That type of enticements, attractions he can do. And when you cannot keep in your account beyond 40 child worker, beyond 30 adult worker, what you will do? From this year, when you move to next year, this year's will be added. It will still be 40 only. If you unavail this year's leave this year, then when you move to 2021, your unleave account will not be 40 plus 14. Okay, even if you make that calculation 40 plus 14, how much it will be? 40 plus 14 is equal to 40. Because in the account you cannot you cannot keep in the unavailed leave account, you cannot keep for more than 40 in the case of child worker or for more than 30 in the case of adult worker. So what you will do before the lapse and before the end of the year, what will be wasted, those number of days he will go on leave. Will it not disrupt the work of the employer? Therefore, what he will do? He will announce, hey, leave encashment. When it is pronounced, don't you think you will get extra? Over and above this 30 and 40 you will keep in terms of emergency. Or when finally you are leaving or terminated from the job, you will even be paid by the employer towards those number of leave that is there in the leave unavailed in the earned leave account. Correct? Okay. How to avail? If you are in the public utility service, you can avail maximum 3 times a year. But I struggle to use the word maximum. That's what law says. 3 times a year you can take earned leave provided leave is there in your account. But in times of emergency, it could be even more. But how to avail them? If you are working in an establishment which is public utility service, like public transport system, like BWSSB, like power corporation, like whatever, then 30 days in advance you should make an application to the employer 30 days well in advance for availing the earned leave. But of course, this has got exception. What is it? In times of emergency, no need of it. Someone has expired or someone is serious, then you will go on earned leave. Even if you are in the public utility service, no need. You can go straight away. And in any other case, this is what public utility service. In any other case, you should apply well in advance, 15 days to the employer for availing the earned leave. That's it. Okay. This is what entire Factory Act provisions. There will be questions like, discuss the provisions of safety, welfare, or discuss the provisions in the Factories Act regarding health and welfare, health and safety. One, that is what most likely among those 3. Whatever question comes, either from this part or this part, I think you need to know the later part also, because from the later part they will design the problem. From the earlier part, they may design the problem, but they will surely design the essay type question. It is needed. And any question comes here, if it is a problem, don't write objectives, introduction and all. Straight away solve by quoting the relevant provision. But if it is essay type or short note type, depending upon the length of the answers, if it is longer or shorter, you need to write appropriate introduction and its objectives.